Hello, I'm James Flexer, attorney of the Law Offices of James Flexer. We have offices in Nashville, Tennessee, Columbia, Tennessee, and Murfreesboro, Tennessee. We practice in the Middle District of Tennessee, which is approximately the middle part of the state from the Tennessee River over to approximately Cookeville, Tennessee. Chapter 7 bankruptcy allows individuals to wipe out or discharge their unsecured debts and not pay any of them. The most common examples of unsecured debts would be medical bills, credit cards, payday loans, and deficiency balances where a car or furniture has been repossessed and sold and a balance still remains on the debt. These debts and most other debts can be wiped out in a Chapter 7. Some type of debts, however, cannot be normally wiped out in a Chapter 7. These would be student loans, taxes owed to the IRS, criminal fines and restitution, and child support. These debts will still be owed in most instances after you complete your Chapter 7. If you also have secured debts such as a car or a home which you are making payments on, you can keep this property if you can continue to make regular payments on the debt and remain current and up to date on the contract. If you do not want to keep the property, you can surrender the property and you will not owe any deficiency balance, as we've just discussed. A typical Chapter 7 bankruptcy that we see in our office would include someone possibly recommitting to finish making the payments on their car, their home, and maybe their furniture, so that they could still keep it, but still wipe out the rest of their debt. But at the same time, they could elect to, let's say, keep the car, but give the home and the furniture back. Or simply keep the home, but let the car go back. So you do have choices, and of course there's also Chapter 13, which we're going to talk about in another video, which will explain to you that even if you were behind on the car or home or furniture, you could still keep or retain that property. The whole process in Chapter 7 takes approximately 3 to 4 months from when you originally come into our office to file to when the court grants you a discharge order. The discharge order is a federal court order that states that you do not ever have to pay the debts that were discharged ever again. Typically, you do have to go to court at least once. Your employer is not notified in a Chapter 7, and from the moment you file Chapter 7 bankruptcy, your creditors must leave you alone. This would include garnishments, phone calls, letters, and lawsuits. All these actions must be stopped immediately. If your creditors wish to communicate with someone about your case, they must communicate with my office. If they try to go behind my office and go to you directly, you should let us know so that we can address that with the court through some type of motion for sanctions or for contempt against the creditor for attempting to collect a debt. We will talk more about Chapter 7 in other videos, which I hope you will watch. We welcome you to request books from us if you would like on Chapter 7 and Chapter 13, or go to our website, www.flexerlaw.com. Thank you for your time and attention, and we will be talking on other videos.